this is, an opportunity to earn 10 Randall points, right? It's just those 10 bonus points. This is not, if you go back and look at the syllabus, this is not figured into the 300 points that you can earn. This is an opportunity to just earn right up front, early in the class, 10 extra points that just get added to the rest of your score without my increasing what you need to know or what you need to earn in order to get an A or a B or a C. So I'm gonna run through these in a minute. Let me get them out, and when everybody gets back in, I'll run through, make sure everybody's on the same page. Most of these are things we've talked about already. If I haven't, that's why I'm gonna go ahead and reiterate them. That's not thunder, is it? What's that noise I keep hearing? Somebody's throwing furniture around. Who's playing tonight, Mel?
No, I can hear it too. No, I don't use it.
Alright, I can miss that one, I guess.
The Los Angeles word.
Bless you. Alright, this will be enough. A few of these we haven't talked about yet. Hold on to. So, for those of you who came back in, what I decided to do to kind of jumpstart your studying for the test, which is now going to be September 26th. I'll post that on Moodle, and I'll also send an email out to everybody to remind you. So your test, the syllabus says test one is next week on the 19th. It won't be until the following week, on the 26th. But on the 19th, next week, when you come in, we're gonna have a short, matching quiz. There'll be 10 questions. They will come from these terms, and you just need to be able to match it up with the appropriate letter that explains what the terms are. So let me kind of run through this. Litigation is simply the whole process of lawsuits, right? The process through which people file suits against each other and carry them forward. So that's all that is. Complaint, if you remember, is what we call a lawsuit when it's filed in federal court. Petition is what we call a lawsuit when it is filed in state court. Complaint is federal court lawsuit, petition is state court lawsuit. Defendant, as you all know, is the person who is sued, or in a criminal case, the person who is accused of a crime. Plaintiff is the person who files a civil lawsuit. Jurisdiction, venue, standing to sue, we've just been over that, I'm not gonna cover those again. Appellant is the person who files an appeal, who takes an appeal. Usually, the appellant is the losing party, person who lost at trial and now wants the appellate court to see if the trial court did something wrong and reverse it. Appellee is the person against whom the appeal is filed. Most of the time, the appellee is the person who won in the lower court. Oh no, I don't want to appeal, just leave it alone, I'm more than happy, right? Long-arm statutes, we just talked about those again. Pleadings is just all the paper filed by the lawyers in a lawsuit. Everything from, and I'm gonna pass these out to y'all tonight, you're gonna have to share them and take a look at it as we're talking about them, but I have a set of pleadings that I want you to at least look at. You can kind of see on the top, it's actually a petition for damages. You can see what a lawsuit kind of looks like. You can see what a defendant's answer to the lawsuit. Here's the petition, here's the defendant's answer. To save paper, I did this two-sided, so you're gonna probably have to flip it around. Also, we have a set of interrogatories and a set of request for production of documents. I'm gonna talk about that in a few minutes, so I'm not gonna explain that right now. Discovery is a phase of the lawsuit. We'll talk about that as well. Damages, you'll remember, is what? Money, right. Preponderance of the evidence is the standard by which a person must prove her civil case if you want to win. That is, if you're suing a defendant for money, for damages, you have to prove your case by a preponderance of the evidence. That is, you, the plaintiff, have to prove, you gotta come up with more proof than the defendant does in order to win, because the plaintiff always has the burden of proof. Beyond a reasonable doubt is the standard of proof in what kind of case? Criminal case, right. So if the state is accusing someone of a crime, to prove that person is guilty and get the jury to convict that person, they've got to prove their case beyond a reasonable doubt. Common law, remember, descended from England, and the common law basically is based on court-made decisions. The civil law, like we have in Louisiana, is primarily based on code articles or statutes passed by a legislature. Okay? Federal question of diversity we just finished. Okay? So all of these terms are in your textbook as well.
Statues
Yeah.
Statutes.
and what else?
I'm
Codes
gonna
of
talk about that.
statutes.
I'm gonna talk about these.
Codes, yes, codes, COD.
Okay, so I'm gonna go ahead and pass these out. I don't really have a set of interrogatories or request for reduction per se, but what we have here is interrogatories are just a fancy legal term for questions, right? And I'm gonna talk about that in a minute, what role these play in working the case up for trial. So you'll see here, this document is actually answers to the interrogatories, but it tells you what the interrogatory of the question is, and then it gives you the other party's answer to it. So just wanted y'all to kind of be able to take a look at that. There's a mishmash of different kinds of pleadings in here, and there's a jury verdict form, you can take a look at that. There's a request you're not responsible for any of this test or even the quiz, except for the stuff that I'll be talking about. So, again, I don't have enough copies for everybody, it's just too much paper. And most of you would take it and throw it away anyway.
You
So,
don't have to.
pass them
Share it
around
with
if you
you.
would,
Oh.
you got
If you don't
one?
mind. I have a question.
Yeah.
What is the word under interrogatory? A request for what?
Production? of
Production of
documents.
documents.
So take one of these, VP, and pass them back up the row, so everybody has at least one on their row. And you guys who are hoarding those, I'll give them to you, you can have them, but circulate them a bit so other people can see them while we're talking about it. Okay, so here we are, ready to essentially start our case at this point. Start the trial. Everything's set up, all the early stuff, the lawsuit is filed, all the damage is done. So we're gonna start a trial. But before we do that, I wanna talk really about, how you get a lawyer and some of the considerations there, with respect to hiring a lawyer and then getting your lawsuit filed. So, we'll first talk about selecting an attorney. In my judgment, the very best way, yeah, any of y'all who wanna come up and take a picture of this, you can do it at the end, it's gonna be up there, the whole class, you can come do it after. The very best way to pick an attorney, in my judgment, is really word of mouth. Like, if you need a divorce lawyer, for example, call up a friend who's been divorced and say, who did you use? You know, because that way, you're talking to somebody you trust and ask them if they're happy with the results. Another way of doing it is to, you know, go online or the old school way to, old book, the yellow pages and pull one up, but that's kind of random. Really the second best way to do it, if you don't know anyone who's hired an attorney, you can't get a personal recommendation, is really to, call the Louisiana State Bar Association, whose offices are in New Orleans on St. Charles Avenue, and they have an attorney referral line. You tell them you wanna speak to somebody with their attorney referral service, and when you talk to the person, you tell them the kind of case you have, and tell them you're looking for a lawyer who's kind of specializes in that particular area of the law. And they will give you a list of names and contact information. Yeah. No, I'm not going to take y'all through it, except I am, but not specifically. So I want y'all to look at it, see what it is, pass it around, share it with everybody else, okay?
Guess I'll look at it.
Okay, so you need to hire a lawyer. So picture this, right? When you go in to hire a lawyer, the lawyer doesn't know you and you don't know the lawyer, right? So you're hoping things work out, but it's kind of a shot in the dark. You know, maybe the lawyer inspires some confidence, maybe she doesn't. Maybe the lawyer thinks the client is full of it, maybe not. It just kind of depends. So when you set up an appointment with a lawyer to talk to the lawyer about possibly handling your case, we refer to that as the initial conference. In many cases, particularly if you're gonna be the plaintiff, if you're gonna be the person filing the suit, oftentimes the lawyer will meet you for this initial conference where the lawyer learns about the case, without charging you, particularly in plaintiff's cases. Lawyers will usually say, come on in, bring any documents that you have in your possession that relate in any way to your claims and the dispute, and come in and talk. I'm gonna interview you, I'll get facts from you, we'll talk about what law applies to the facts, and we'll decide if we wanna enter into this attorney-client relationship. Now, you are not required in any setting to have a lawyer. Anyone can represent himself or herself. If you are representing yourself, particularly as a plaintiff, you are referred to as a pro se plaintiff. Again, the endless Latin phrases in the law, pro meaning for, se meaning oneself. So for oneself, I am acting as my own lawyer, I don't have a lawyer.
Is that an A?
Say it again? Pro se, S-E.
S-E.
So you can do that anytime. It's not always the most advisable route, but you can do it. I will tell you this, in my experience, courts tend to bend over backwards to help people who are representing themselves. It always used to hack me off as a lawyer, like, okay, seriously. You know, how many chances you're gonna give this person to, like, get it right? You know, judge keeps giving it back. Come on, judge, throw the suit out. No, I'm gonna give him another chance to amend it and fix it. You know, maybe we can state it correctly. Okay. You know, so it's not always a bad deal, and you certainly save you money if you're representing yourself, but like I said, not always the best. It depends on the case. So you go for this initial conference, and you're gonna meet with the lawyer. The lawyer is going to ask you to explain the facts of the case. The lawyer's gonna ask you, do you have any proof of what you're saying? Because lawyers have an ethical obligation before they ever file a lawsuit to investigate the facts. Now, my area of the law, what I practice mostly is plaintiff's employment law. So, well, I used to practice plaintiff, now I'm doing defense, but when I was representing plaintiffs in employment discrimination cases, people would come to see me, they just lost their job, right? So, I'm supposed to investigate their claim, but they're not in a position to bring me a whole lot of documents or anything, because they're now on the outside, right? So, how do I investigate? So my approach always was, let's take a sexual harassment case. Did anybody see this male supervisor sexually harass you, or hear any comments he ever made to you, any of that? Yeah, a couple of my friends at work, okay. So what I then say to the potential client is, I need you to contact those people and ask them if they would be willing to talk to me. And then let them know, if they say, then you need to let me know if they say, okay, I'm gonna call them and I'm gonna interview them and ask them, what do they know about the case? That's the best I can do in terms of investigating the claim before I file a suit, right? I don't know this person from Adam, she just walked in off the street. I'm hoping she's honest, I'm hoping she's telling me the truth. So I'm trying to fulfill my ethical obligation to investigate the claim before, yeah.
You know, when you're interviewing them, you have to do a formal deposition.
No, this isn't deposition, we're nowhere near that yet.
Okay.
This is just potential client talking to potential attorney. So after the person tells me in the initial conference the basic facts, my job then is to explain to that person what the applicable law is, what law applies to the facts of your case. Then my job is to assess for that person what I think her chances are of prevailing in a lawsuit against her former employer. Now, I don't have a crystal ball. Lawyers, under our Code of Professional Responsibility and ethical obligations of lawyers, we are never allowed to guarantee results. And any lawyer that does that is just stupid. You're asking for it. There's no way at the initial conference you can tell this person, oh, this is a slam dunk, I'm gonna make you a millionaire. And in fact, a lawyer who says such things to you, in my book, is more of a cheerleader than a lawyer. Oh man, you got screwed, come on, let's go, I'm gonna make you a millionaire, I'm gonna make $5 million myself, let's go get it. You don't want that. You don't want that. Here's why. Litigation is just really difficult. It's emotionally draining, can be financially draining. If you're the plaintiff, you're reliving all the bad stuff that happened to you, right? And believe me when I tell you that employment law, thank you, Dave, employment law is very much like divorce law. But instead of divorcing your spouse, you get divorced from your employer. So there's all the same sort of self-esteem issues. You know, I was a good employee, I did a great job for these people, and look how they're treating me, blah, 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 right? So you want a lawyer who's in touch with reality, and who's going to say to you, I can't predict, but I think you have a 50-50 chance of succeeding, or maybe even a 60-40 chance of succeeding. But you gotta decide, do you wanna put yourself through this, and or your family, or your significant other? Because this ain't no picnic. Lawsuits are not fun. You will be ultimately sitting across the table from the lawyer for your employer, who will be taking your deposition, and who may or may not, make your life as miserable make you as miserable as you've ever felt over anything. Accusing you of being a liar, challenging you, et cetera, et cetera. You need to make sure that the lawyer is giving you a realistic evaluation of your chances. Beware of lawyers who are going to help you chase rainbows. Chasing rainbows is a beautiful thing, but it ain't getting you anywhere in a lawsuit. You got to deal with the facts of your case, the law that applies to it, and you want an honest, expert's opinion from the lawyer about what that lawyer thinks your chances are of being able to prove your case. A lot's going to depend on what your witnesses say, which is why the lawyer wants to at least preliminarily talk to the people you say who might be your witnesses and get some information from them. So after all of that is done, you're not necessarily going to have to make the decision right then and there. You might be interviewing several lawyers. But at some point, you agree that you're going to hire this lawyer. So now we need to talk about the most important thing, of course, and that is, how's the lawyer going to get paid? Here I am. Whoops. So, if you are going to be the plaintiff in the case, most of the time, the lawyer is going to, or you're going to want the lawyer to take the case on what we call a contingency fee basis. A contingency is a condition, right? Anybody know? Well, I know somebody does. Somebody other than somebody else, somebody who doesn't work in the legal field. Anybody know what a contingency fee arrangement is? Go ahead.
Sorry, I thought the definition of contingency. What was the last part?
Contingency.
Yeah, it's basically just like part-time, something that's not like full work. It's just a fill-in.
A contingency is a condition. Well, what's a contingency fee case? Go ahead.
The lawyer gets a third of the judgment.
There you go.
The judgment, they don't get paid.
That's exactly right. The lawyer's fee comes in the form of a percentage of whatever money he recovers for the client. So, traditionally, lawyers who take cases on contingency fee basis have said to their clients or put into their contracts, their written contracts, I will handle your case for 33 1/3% of whatever I recover for you. So the beauty of that is, you, the client, you don't have to pay the lawyer as you go along. You're not paying the lawyer for his or her time as they're working the case up, right? You're not getting a bill every month because the lawyer spent 20 hours working on your case at $200 an hour. You're not going to deal with that. What the lawyer says to you is, and 33 1/3 is kind of on the low end these days. Most people are at least at 35%, and a lot of times contracts now will say 35%. I'll take 35% of whatever I get for you if I get that for you before we go to trial. If I got to go to trial and we win, I want 40%. If we lose and I got to appeal it for you and we win on appeal, I want 45%. It goes up, okay? So you don't have to agree to that. You can, and here's an important point. The actual percentage, it's negotiable. Now many lawyers will tell you it's not negotiable. I don't take a case for less than 40%. Well, okay, maybe that's not the lawyer for you. But you can always ask the lawyer if he or she would consider taking something less. But here's the problem there. It's a contingency fee. So you're not getting regular bills for the lawyer's time as the case wears on. But in the end, if the lawyer gets nothing for you, either by settling the case or by trying it, if you lose and you get zeroed, 35%, 40% of zero is zero, right? So the lawyer ain't getting paid and you ain't getting any money. But here's the worst part for you as the client.